Our webinar today is Lessons from the SEC's Crackdown on Software Transparency. And that is something that has been getting a lot of attention in the last couple months. Going on to the next slide. Before we get going on that discussion, just take a couple seconds to understand or explain to you what ReversingLabs is all about. And so we are in our 15th year as a company. And since over the past 15 years, we have just been continually improving our solutions, become a trusted authority in software and file security. Our threat repository is the world's largest. We track over 40 billion with a B files, both malware and goodware and grayware. And that number, it obviously continues to grow every day as our threat research team is methodically analyzing, categorizing new instances of malware, goodware, grayware, and so on. And that 40 billion file repository or file lake makes us about 7 times larger than our closest competitor. What most people don't know is that more than 60 of the leading cybersecurity companies in the world trust our data and threat intelligence to give feeds for the solutions you're already using. So you may, if you're using cybersecurity technology, you may already be using ReversingLabs technology behind the scenes. And we're work with channel partners. We recently received accolades for our premier channel partner program, along with being recognized by Gartner as a leading software supply chain security provider. We were also a contributor to the 2024 edition of the Verizon Data Breach Investigations Report. So our data on software supply chain security was part of Verizon's DBIR. So that's ReversingLabs. If you want to check us out, reversinglabs.com is the website. Please do so. So my guest today, we got a really great conversation planned for you. The first is my colleague, Saša Zdjelar, and Saša is the Chief Trust Officer for ReversingLabs. He's also an operating partner at Crosspoint Capital, and he's got around 20 years of Fortune 10 global executive leadership. Prior to ReversingLabs and Crosspoint, Saša served as the Senior Vice President of Security at Salesforce. He spent nearly 2 decades at ExxonMobil, holding various positions focusing on strategy, enterprise security and architecture, software engineering, ERP systems, you name it. So Saša, welcome.
Thank you, Paul. Very, very, very happy to be here and very excited to engage in conversation with you and David.
Yeah, as are we. Our other guest is David Hirsch. David is a partner at the firm McGuire Woods and a former senior SEC enforcement officer. And David, if you could, give us a little introduction.
Sure, absolutely. So as you mentioned, I recently from the SEC, I left in June of this year. My most recent role there was as a senior officer in the Division of Enforcement. My title was Chief of the Crypto Assets and Cyber Unit. So we were a big team tasked with investigating potential violations of securities laws as it applies to cybersecurity processes and procedures, disclosures. We were very busy with crypto, as the FTX era and aftermath, and also looking at other emerging technologies that may play into the 2 primary areas of focus. Before that, I was counsel to SEC Commissioner Carolyn Crenshaw, and before that, I had 5 years of frontline staff attorney running my own investigations into issues relating to cybersecurity and crypto.
Okay, so you have been in the trenches for the types of things that we're going to be talking about today, which is just awesome. And we're so thankful to have you, David. Thank you. So just some background here on what we're talking about. Obviously, if you're not aware, on October 22nd, the SEC made an announcement that named 4 current and former public companies that were customers of SolarWinds as receiving penalties for making materially misleading disclosures regarding cybersecurity risks and intrusions. And those 4 were Unisys Corporation, Avaya Holdings, Checkpoint Software Technologies, and Mimecast. Unisys was additionally charged with disclosure controls and procedures violations. So those companies agreed to pay civil penalties ranging from $4 million in the case of Unisys, Avaya $1 million, and Checkpoint and Mimecast both slightly less than $1 million. That followed fraud charges filed in 2023 against SolarWinds itself and its CSO, alleging those are fraud charges, alleging that they misled investors about the true nature of their cyber risk following a really massive software supply chain compromise attributed to Russian actors that affected the Orion software. Okay. So that's the background. That's what we're here to discuss, which is both the SolarWinds case and the case against SolarWinds customers were kind of new ground for the SEC in some ways. So I thought I'd start off, David, with you. You were a senior SEC enforcement officer. First of all, maybe just explain to us what that job is all about, and in general, what kinds of cases as an enforcement officer the SEC is typically pursuing against companies, at least during your time there.
Sure. So within the division of enforcement, there are a variety of kind of hierarchical levels of staff, as there are in all, I think, government bureaucracies. And so you start as a staff attorney, and then you can become an assistant director, which is roughly equivalent to manager. There are some specialist roles, and then the leaders of kind of larger teams are given the title of senior officer, and that was the title that I held. In that role, I was responsible for supervising a team of managers who in turn supervised a team of staff members, all of whom focused on trying to deploy resources efficiently to look for potential violations of the U.S. securities laws in areas of particular priority for the commission. The 5-person commission runs the agency. They get to determine what the priorities are for the enforcement division, as well as the other divisions within the agency. The chair has an outsized voice in that. Typically, the chair, or always the chair, is appointed by the sitting president and is of the same party, and typically there are 3 of the same party and 2 of the minority party. The 3 in the majority tend to make the rules and decide what the priorities are going to be. That was, I think, fair to say, accurate during my tenure. A lot of unanimous votes, but not exclusively unanimous votes among the commissions. And then it's everything from intake, where we get a lot of tips, complaints, and referrals in at the SEC, come in from the public, come in from companies, come in from whistleblowers. People can just identify potential issues to investigate. Staff members can just from newspapers or public media, and then try and decide of the tips and ideas and concerns we have, where to deploy investigative resources. And then if that investigation proves that there was more likely than not a violation, then there's a recommendation prepared for the commission to decide on whether to authorize either a settlement or to proceed to court for mitigation.
So I think that the reaction to the case against the SolarWinds customers was sort of like, whoa, like this is new, this is new territory here. This is new ground for the SEC. Is that true? Was there anything unique about these particular charges filed against SolarWinds customers back in October?
There's always something unique. Each of these cases is based on the specific facts and circumstances presented. And so in some ways, that is always true and was true here. I think what is somewhat unique is these were 4 cases that came out at one time. That's not traditionally the way that the SEC has been bringing enforcement actions in the context of cyber, although they sometimes do sweeps in other areas and will announce a number of cases together. The other thing that was a little unusual is that all of these cases had the same kind of predicate, vulnerability, which is they had software supplied by SolarWinds that they trusted, and that proved to be the attack vector that led to the problems that the SEC was concerned about. So that's somewhat unique, and I think it raises some questions of, is the SEC striking the right balance between holding companies accountable to the extent they're not being fully disclosed, like not providing full disclosures to their investors in ways that they should be, versus not wanting to re-victimize an entity that has already suffered as a result of a cyber incident here as a result of kind of the downstream impacts of the SolarWinds.
Saša, what was I'd ask you, what was the take within the sort of InfoSec community, certainly amongst CISOs and InfoSec leaders, on these charges in October? What was, just looking at your network and the reaction, what sense did you get?
Yeah, I think it goes back to something that David just said, which is, were there potentially misleading statements made? And I think every CISO kind of shook at their core to say, boy, I wonder what statements we or I have made. And the reason I say it that way is prior to that Wells notice, it was not uncommon for a CISO to provide a, state of the union kind of from a cyber perspective on a quarterly basis to the board, or even in a rep letter, representation letter on a monthly basis, up to the board. And that was usually written very academically, very matter of fact, very kind of here's what is and here's what isn't. And usually was accompanied by, and this is why I need more funding and, this area and that area and identity and patching and whatever. Except it was also quite routine practice for, that to be kind of sanitized and modified as part of the preparation of board material. So it was not uncommon for, the phrasing that the CISO would use to go through some, marketing and public and government affairs and other communications team filters that would say, well, oh boy, this, sounds better when we say it this way. It just flows better. If it's a better flow, like words like that would kind of not tell you we don't like what you said, but it was kind of like, yeah, this just sounds better and it flows better. I think it just kind of it just gets right to the point.
Just
And
pacify the English majors in your organization.
that's
Yes.
That's it, right? The grammar police or yeah, but the challenge with that is it would often, take the message from something like, I'll be a little bit hyperbolic here, but the message that the CISO wrote was something analogous to we're woefully underfunded and we're not patching fast enough. And the final, outcome that has been dressed up will sound something like, complete immunity from advanced nation state adversarial attacks or whatever. And it's like completely opposite ends of the spectrum, right? That have nothing to do with each other. And I think that's when they saw that Wells notice, what it made them think of is like, boy, what am I on record theoretically having said? And what might the implications of that be, not only for the company, but for now, all of a sudden, my own personal liability, right? And so there were a lot of fire drills to go back and scramble what's on our website, what's in our filing, what's in our documentation, and then taking it a step further, what conversations, frankly, have we had about the modification, of those of the wording of that, because all that is subject to discovery, right?
Here's the 8K or the 10K we put out. What did we know at that time? And is somebody going to hold me to account for, well, you knew at this time and then you put out this, right? I mean, that is right. That is what's freaking people out. So David, at issue here is publicly traded firms' disclosure of material cyber incidents, cyber events, which I think the high level understanding is anything that might influence investor behavior. But I'd ask you, help explain to the audience this concept of materiality in the context, well, in general, and also just in the context of cyber incidents.
Sure, happy to. And before I get there, I wanted to piggyback on some of the good things that Saša had to say. And so one of those is looking back at the original SolarWinds case, and did involve naming an individual, the former the CSO, Tim Brown. The allegations regarding the public disclosures that have survived the motion to dismiss. So there's already been some procedural conduct in that case where company and Tim Brown moved to dismiss a number of different charges. The court agreed with them on some, including those that said that there were inadequate internal accounting controls because cybersecurity wasn't locked down enough. And the court effectively said that might be a poor control, but it's not an accounting control. Accounting controls really go to finances, and cyber is something else. And so that charge does not sit well. And so we may see fewer of those charges going forward from the SEC. The charges that survived had to do with statements that the company had made and were attributed to Tim Brown personally that were customer facing, primarily talking about the level of security maturity and kind of the approach they were taking and process that they had in place for software development lifecycle that may have been inconsistent with what the SEC later found and included in their complaint regarding internal communications that were happening as to the state of readiness and maturity. And I think that raised a couple of sort of novel issues for security professionals and for companies, which is you don't always think about customer-facing communications as also being investor-facing. And clearly, by the SEC's charges, they see those two as closely aligned. So if you're talking to your customers, you should assume that your investors may also hear about it and may take seriously what's being said in a way that you hadn't intended, but you need to now control for. And the other one is it's not always clear, I think, for security professionals what the company is out publicly saying about their level of security when they're trying to use it as a marketing pitch. And if CISOs don't have visibility into what the company is outside saying, you run a greater risk of this type of mismatch between public-facing documents and what's actually happening within the company, or what the internal dialogue is like within the company about the state of readiness and level of maturity. I just wanted to add a little bit of additional detail to that. And in terms of your question about materiality, yeah, the Supreme Court has issued some guidance on that over the years. It's, I think, broadly termed, and generally something that a reasonable investor would consider to have altered the total mix of information available about the investment. I try and think of it a little more shorthand is it something that is likely going to make a average investor make a different decision about an investment, or reconsider what they thought they understood about the investment they'd already made. And that's very broad, and I think by design. One of the challenges for the SEC is the public companies they are responsible for overseeing run a huge gamut of size, sophistication, industry, technology, and lots of other things. And so laying out a set of common expectations for such a broad variety of entities can be very challenging. And so typically the SEC prefers to do things on a principles basis and says, if this is material, then you have to disclose. We're not going to tell you what's material because we couldn't define it for each individual company within our team or within our remit. So you have to sort of sort it out for yourself. And there is a strong tradition within kind of corporate reporting and the auditing community about how to think about materiality in the context of financial reporting and lots of other different metrics that companies think about in terms of what the future might look like and which of those details our investors have a right to know and the companies have an obligation to disclose. In crafting the new public company issuer disclosure rule that the SEC adopted in 2023, went effective in December 2023, the guidance around that said materiality is materiality. It's not a special standard for cyber. You should be using the same sorts of approaches that you have used in the other contexts with which you are familiar, but obviously you then have to tailor that to the particular circumstances of your company. So think about the particular industry you're in, the types of threats that that industry is subject to and that your company is specifically subject to, lived experience and what types of risks had led to incidents in the past and other things like that, and use that as the lens through which to frame your analysis of cyber materiality for making disclosures out to your investors.
Yeah, and I think it's also,
go ahead, sorry.
I think also important to point out that materiality is highly differentiated and completely unrelated between companies, right? It is always in, this in kind of from the perspective of the company defining the materiality. For example, one of the companies I used to work for, the company was so large that at the corporate level, in impact, let's say downtime of a financial reporting system or financial processing, order taking, whatever, would not be considered material. And this was prior to any actual regulatory pressures around materiality. Just the company itself internally said, look, we need to define what material for us means so that we can make internal decisions. Do we freak out? Do we stand up another one? Do we call for help? How would we decide what's material before the regulators even start asking? And the threshold was 500 million. Nothing under 500 million would even be a blip on the quarterly filing, given the level of revenue and profit and everything for the company. That exact same thing would not translate to a ReversingLabs, obviously, or a small tech company or something like that. So this concept of materiality and what hinges as a result of that decision, your reporting of incidents and how and to whom and how quickly, all kind of hinge off of this definition that every company has to determine for itself, and then be able to defend, how they came up with that.
Right. And it's easy to see for companies with, trillion-dollar values, right, that hardly any cyber incident might be perceived as material just because these companies are so huge, and cyber incidents, like, while they might be costly. So it sort of challenges that notion that materiality is something that just boils down to dollars and cents, right? If you want to buy a company that has some technology, and lo and behold, some nation state actors been, crawling around their network for the last year, stealing their intellectual property, that might not cost you anything as a company, but might be highly material, right?
Well, I'll tell you the incident that led to a lot of very large kind of mega global corp America considering this very seriously and looking at it was around 2017 when WannaCry and NotPetya happened, and you had companies like
Yeah.
Merck carry, $500 million encumbrances for 3+ quarters. All of a sudden now you were in the 1.5, billion kind of range. Now those start being, those are not rounding errors even for those $1 trillion companies. That starts
That's
being
right.
profound. And so I think as far as I can recall, those are the first really material or well-educated, well-informed conversations around materiality that I recall having was around kind of the 2017 timeframe.
And I
So
should add, the SEC
go ahead,
guidance
David.
has
Yeah.
said, as you indicated, Paul, it's not just quantitative materiality, it's also qualitative materiality. And so you can't necessarily just count the number of devices and say, well, we only lost 100 devices out of 1 million and therefore we're good. You have to think what was on those devices. There's some other reason why the impacts may be more important for investors than just based on what accounting or the numbers or the dollar figures might indicate.
Yeah. So let me remind our audience, we're really interested in your questions. We want to know what is on your mind and what you're thinking as we're talking. So use the Q&A feature. We'd love to hear them. And again, we'll kind of take them as they come. So if you got questions, throw them into the Q&A feature. So on the question of materiality, I mean, I think one of the challenges in cybersecurity is that there is just a huge spectrum of cyber risks and cyber incidents that especially larger companies are dealing with. And Saša, you were at Exxon and Salesforce, so you know this firsthand. Everything from malicious email attachment or phishing email to an employee, very small blast radius generally, but could be bigger, to company-wide ransomware attack or business email compromise that redirects, hundreds of millions of dollars from your accounts to some cyber criminal accounts. How should a company, how should a CISO or a corporate board think about those cyber incidents in terms of measuring materiality? My guess is a lot of them just are not material. It's just background noise. Some of them are. Is there any ruler or guidelines that they can use to try and rate stuff that might be popping up in their discussions in their board meetings or their C-suite meetings? David or Saša.
Oh, that's for me? Okay. Yeah, sorry. I thought that had been for Saša. I mean, yes, like the company should have a strong set of processes and based on assumptions that have been tested over time to try and determine like what are the things that have been most impactful for our company in the past as far as when we see an incident, what kind of consequences does it lead to? Is it something that's quickly controlled? Is it something that leads to lingering issues? Does it potentially migrate out to customers or others that would be reputation harming, and how do we think about that? And usually the base they start from is their typical materiality analysis, which exists within the company. If they're publicly reporting, they're thinking about materiality in the context of their periodic reporting, their Qs and Ks. And so now you're just trying to tailor that more to cyber. I think one of the best practices you can have at the kind of executive management level, because materiality is determined by executives, not by the board. Typically, board may have an opportunity to consider what's being publicly disclosed before it's publicly disclosed, but normally that function sits at the CFO level with input from other important players, including general counsel's office and others within the company. For cyber, obviously, I think a best practice is to have somebody from the cyber function in the room providing context, making sure that the decision makers thinking about materiality are thinking about it understanding the technological implications of what's happening, which is not necessarily a baseline that every CFO has. And so having somebody from security to be able to explain it and talk about it is really helpful, and to be able to provide some context for what other things have been seen in the industry. One thing that we saw in the public after the SEC issued that new rule that went effective back in December, initially a lot of companies that suffered cyber incidents filed a Form 8K, which was required under the new rule. It says that once you've made a determination that an incident was material, you then have 4 days to notify the public through filing a Form 8K, which included a new cyber item which is the box within which you would talk about what the cyber incident was and its impacts. A lot of companies, after that new rule went into effect, started filing 8Ks after incidents in which they would say, we don't think this was material. We don't think it had a material impact on our finances or on our operations. And I think the idea was, we don't really understand how the SEC thinks about materiality. And so we don't want to get this one wrong.
Better safe than sorry, kind of.
And yeah, out of an abundance of caution. So I think of those as kind of defensive filings. And that went on through about May. And then the director of corporation finance at the SEC issued a statement saying, really appreciate it. Please stop. Like, if you want to disclose a cyber incident that you don't think is material, there's another box in the form you can use. Don't use the one for material cyber incidents. And that he would express some surprise how quickly companies were coming out with Form 8K filings post-incident, and I think indicated that the idea was the standard is you have to make a determination without undue delay, and the idea was you want to give the company enough time to really think about what is happening, what the potential impacts of the incident are, to have those kinds of detailed discussions at the executive level before you go out to investors. And if you're doing that within 2 days at the same time you're responding to an incident, maybe that's almost too fast unless you're really sure that you know that it's going to be material. And so I think it was cautioning people to take enough time necessary, that it wasn't going to be a race to the disclosure window. You just can't unduly delay making the determination.
Yeah, what's
Saša,
interesting,
I mean,
what this makes
yeah.
me think of is, you know, traditional business continuity kind of plans, right? If you think about how you determine probability times impact equals risk, you say, okay, well, this is a high consequence but low probability event. Okay, for that we're going to have this kind of plan, that kind of plan. And normally, the kind of businesses have for that are things like, in other words, when they have robust plans, it's because there is something that could lead to a material disruption. And so they have plans for things like mass loss of people, mass loss of facilities, pandemic. Those are kind of your typical high loss, in other words, material scenarios where you normally have plans. What they don't necessarily account for, because they're somewhat asymmetrical in cyber, is you might be operating exactly as you were yesterday. The difference is now someone else has a copy of all your data. I don't know what BCP kicks in for that, and the answer is none. But there's still materiality. So I think it's just an entirely different way of thinking when cyber is kind of the vector versus one of the more symmetrical traditional ways that you plan for material losses for an enterprise that have nothing to do with cyber.
Right. So Sam asked a question in the chat. Do you think there's a conflict of interest in having CISOs often reporting to the CTO, Chief Technology Officer? To Sasha's point of watering down the message, do you think the CISO should always have a direct reporting line to either the CEO or the board? This kind of speaks to, the impact of the case against SolarWinds CISO and some of what followed from that, which is, well, if we're going to be held liable, then we need more authority and decision-making power within organizations. So, Sasha, I'd be interested in your response to Sam's question.
Sure. So this may not be a popular opinion, but I'll tell you, I'm one of the kind of security folks that over 20 years and having worked in orgs that have completely different org designs, I think it doesn't actually matter at all where the CISO reports. I think I have seen, I have seen fantastically efficient models where the CISO reports to the CIO, for example. I've seen fantastically inefficient models where the CISO reports directly to the CEO. So I would say I discount the org design. So I discount that, but I put a premium on the people in the roles and the empowerment that they've been given. In other words, the visibility, the board relationships, the frequency of interactions, how seriously they take them. If you have all of those elements, where you then are in the org is probably more of a matter of like some personal, career aspirations, and are you really a senior executive? That it's a little bit more of a different set of characteristics than I would say, can you be an effective CISO? I think you can be an effective CISO being anywhere in the org, as long as you have visibility, empowerment, they take you seriously, you have board engagement, So I don't think it's org design. What I will say that I think is maybe a related and very important point is by giving CISOs at some point, 15 years ago, 20, whenever we first started using these titles, by putting a C in their name, right? Chief something, something, something. I think we might have done them a little bit of a disservice. In fact, a massive disservice in some ways, because we gave them on paper seemingly the same corporate directorship or Section 16 officer status, almost like a paper tiger, right? Optically, it looks like an officer of the company or a chief something. Realistically, it usually isn't even close to one. It's, very frequently not an executive at all, as far as a role. It's not an executive role. It's almost never a Section 16 officer for publicly traded companies. It's also almost never a director of the company, meaning legally a director of the company. While some of the other C level ones are, right? A CFO certainly is, a CEO certainly is. And so I think we've done them a little bit of a disservice, because that has put a target on their back and a level of accountability and a level of assumed influence and budget and whatever that actually doesn't exist, right? Or in vast majority of cases doesn't exist. I'm not saying maybe there's some outliers that are different, but by and large, they are not empowered like a CFO or a CEO. They don't have the same budget and they don't have the same kind of focus. So I'll just leave it there. I wasn't say a
And
discount
they don't.
or
They also don't
design.
have the same. Yeah, they also don't have the same protections. One of the things that came out after the SolarWinds case was that CISOs often are not covered under the company's, directors and officers in insurance. That they don't have that, not immunity, but a guarantee from the company to, cover any legal costs that they incur doing their job. David, I'm interested in your thoughts on that.
Yeah, no, I share very much Sasha's views on that. I don't think that there is any one standard org structure that has to be enforced across the board. I think it should be variable based on the specific needs of the company and what the leadership team thinks is kind of best from a structural view. But I totally agree that what's important is the kind of function, the authority, the responsibility. I really like, Sasha, your point about kind of the relationship is not only do you have to have access, but you also have to have the support and the opportunity to have repetition so that when you go in front of the board as a CISO, they know you, they know your work, they know to trust you. And so that you're not just showing up for the first time they ever hear from you is when the world is on fire. Like, that's a hard time to build a relationship. And so the more that you empower the CISO to have a direct line and some opportunities to share things in an unvarnished way, the better the information the board has in which to operate. And I think the challenging point is if you are in a position where you, as a CISO, feel like there is a buffer layer between you and the decision makers, and you don't control what information flows up to the people who ultimately need it, that can put you in a very difficult position. And I don't know that there is great guidance out about how to navigate it. And I think that's part of the process of going from a primarily technical role to the sort of leader role that CISOs are now, I think, either being seen as or being expected to be, is developing those types of tools, guidelines, and processes so that you know that when something comes in, you have a way to handle it, and you're not going to be in the midst of a separate set of conflicts with reporting when you really should be focused on dealing with a crisis or dealing with an ongoing incident.
Yeah, really.
I'll just add maybe one other aspect here that I think is important is, as one of the other real executives, let's say, CFO, CEO, as they get groomed for those roles, right? They spend years, in some cases decades, being increasingly exposed to executive training, education, exposure to kind of the legal implications of their roles with increasing scrutiny. This is another training that is not usually on the path of a CISO, right? The CISO usually is like anointed from on Friday being like the network guy, on Monday becomes like the CISO, and they have not had the benefit of someone who is destined to be a CFO and the kind of grooming that they've gotten including all of the, personal liability and other implications that come with that role. A CISO is just sort of, gets thrown into that overnight. So that's another sort of disservice where we need to find a way to close a gap in the education for CISOs as well. Not to mention, people look at the outsized compensation packages for some of the Section 16 officers and, real kind of directors of the company. What they don't realize is often, a lot of those funds and a lot of that extra, money that they make goes to have things like personal lawyers on retainer and whatever to protect them. So, as Spider-Man quote, right? Great power, great responsibility. There's a great responsibility that comes with it. And along with it comes a compensation package that allows you to arm yourself with all of these defensive and protective, things like having your own attorneys. Typically a CISO, again, with some outliers notwithstanding, they generally don't have the kind of funds and compensation package to have an army of lawyers on retainer to protect them should a case ever come up.
With great power comes great overhead, I'd say.
Yeah. And Paul, to your point, there's two types of insurance issues that CISOs should be thinking about, which are, one, are you covered under D&O? So are you under the total umbrella should there be an issue later? But more importantly, or more immediately, are you part of the group that is capable of receiving indemnification, so that from the start, even before a determination of liability has been made, are you going to be having your attorney's fees covered by either insurance policy or by the corporation? And that's something that CISOs can potentially negotiate, as all executives can potentially negotiate. I think historically it hasn't been done. I think since SolarWinds, there's more of an impetus to do it, but it still leaves a lot of CISOs who have already been in a role for a long time in a difficult position. But sometimes difficult when you're already doing a job to negotiate for a significantly new expense to be added to your package.
Yeah. So I think we have a poll coming up. Do we? There we go. Okay. Personal liability concern is the potential for personal liability influencing how you think about your career in cybersecurity. So this is a very relevant question for what we're talking about, and give you all another 20 seconds or so to answer it. Okay. Another 5 seconds. Okay. So, interesting results here. Yes, significantly is a majority. Well, close to a majority, 50%. Yes, slightly, 28%, and not really, 22%. David, Sasha, interested in your thoughts.
My thought is that squiggle 80 or yes. That's my main thought is that,
Yeah, right. Vast majority, yes, it's on their mind. Yeah,
right.
Yeah.
Yeah, this certainly is consistent with things that I was hearing when I was at the SEC. I would go and speak on cyber, and invariably after I got off stage, people who wanted to talk to me most were CISOs or aspiring CISOs trying to figure out like what their personal liability and obligations look like. And I couldn't give them advice specific to themselves. I could point them to the limited guidance that's been out, but I'm optimistic that we will see more. I think hopefully the CISO community has taken some comfort in the fact that since Tim Brown has been named, the SEC has not named any other individuals as defendants in cyber cases. He was the first one, and so right now that's a data point and not a trend line, I think. But CISOs are, and people who aspire to it, I think, are smart to be concerned and to think about how are they going to approach the job in a way that is going to minimize the likelihood that they are looked at individually, rather than if there's a problem, it's a problem at the company and entity level, because cyber is really a company-wide obligation, not something that rests on the shoulder of anyone.
Are we seeing companies adjust their structure to elevate CISOs to the C-suite, or give them the types of structural protections and safety net that you all are talking about? David, I don't know. I think you're probably the best person to take a swing at that question.
I think it's a little hard for me to discern because companies weren't necessarily disclosing a ton about how they were processing the CISO role internally as far as their public disclosures, and that was most of the window I had into companies, other than in the context of investigation, which I really can't talk as much about. But I think, Sasha, you may have more of a view of this as to whether you or your colleagues in the trade have seen either an elevation of authority, an increase in resources, more access to board, or other things. Certainly the boards who I've been speaking with since being out appreciate the risks and vulnerability for the whole company and the importance of the CISO role in trying to address those risks.
Yeah, I would say this is one of, to me, the more positive narratives in cyber. You know, what is the saying? The arc of history is long, but it bends towards justice, right? So it might be taking a while for this to happen, but I don't see any indications that the trend is anything but towards the role being more senior, more empowered, a more senior member of the leadership team, certainly board visibility. I mean, all of the kind of trends I think we've been hoping for over the last 10, 15 years are happening in some places a little bit faster than others. Obviously, a place that has just experienced a breach, that tends to, get accelerated and happen overnight. Places that are next up would be probably like the more heavily regulated industries, right? That's an area where you see it more. But I think as a whole, broad brush, it's happening almost everywhere. I've even been surprised where in conversations like this, CISOs walk away and they say, wow, I don't know if I have DNO coverage, actually. That's a good point. I should go check that. And then they go check, and actually, to their pleasant surprise, they find that
They
their
do.
role was added 3-4 years ago. Now, the part that's disappointing is they were never involved in the conversation. They never even thought to talk to them. So it's like, is the roles, do they really think more highly of the role or the person in it or whatever? But I know several situations where the person was pleasantly surprised that it was added unbeknownst to them years ago. So I think it is trending in the right direction.
So, David, I think one of the things that struck many people with the announcement in October from the SEC on the SolarWinds customers was just the variety of penalties that were assessed. Again, 4 million down to less than 1 million. And I think probably a big question on the attendees' minds is what influences the amount of those fines? What contributing factors make a fine greater or less? And as a former SEC enforcement officer, my guess is you've got some insights into that.
I do. And, I think for everybody, it's attractive, the idea that you could just have a formula, and if you could just plug in your specific criteria, you would output what your number is likely going to be, and then can move on from there. It's unfortunately significantly more of a black box environment than that. But the types of things that the SEC thinks about are the nature of the violations. If you've got multiple violations, you're more likely to get a bigger penalty than if you've only got one of those multiple violations. Have you had this type of issue before, such that you might be viewed as a recidivist or as somebody who's not taken the message from the prior issue or violation that the SEC had found or thinks you've committed? The size of the entity, the amount of penalty necessary to deter a $2 trillion organization is probably very different than the amount of penalty that would be convincing to a smaller organization that that was a problem. I should not do that behavior again. And then cooperation. The SEC went to great lengths in the orders to talk about the specific types of cooperation each of these companies provided, and the fact that that had reduced their overall financial remedies that they were responsible for, but they didn't quantify it. So that they got some credit, but they don't say what. But it's helpful, I think, to talk about like the types of things that the companies did that the SEC found helpful. Some of it was, sharing details without being asked, quickly responding to inquiries, opening up the investigative file in some cases. But also, I think in most of them, if not all of them, they mentioned the fact that the companies had invested money in remediating and mitigating future problems, and that like investing in your cyber environment so that you don't suffer that type of incident again is something that the SEC supports, not just in what it says, but apparently in terms of how it assesses penalties.
So things you can do as a company after the incident while the investigation is ongoing could actually reduce what the fine or penalty you pay at the end. So it's not like the verdict is written at the point at which the compromise takes place. How your organization responds to it could actually help you.
That's exactly right. And it has been a drum the SEC has beat for a long time, is the importance of cooperation during the course of investigations and reaching resolutions, but they have not necessarily always been as forthcoming as maybe they could be about the specific types of cooperation that the SEC values and will credit. And then ideally, if they would provide a little more information about the types of returns companies get on those investments, I think it would help empower boards and others to make decisions to take the steps that the SEC is trying to encourage them to take.
Unisys received the largest fine, $4 million, and was additionally charged with just problems with disclosure controls and procedures. Could you help us understand what that was about?
Sure. So I had some probably supervisory responsibilities for cyber overall, and by extension, these 4 investigations. So not talking about non-public things that may have happened during the course of the investigations, just talking about what the SEC has said publicly. The things that they talked about were, yes, there were procedure problems at Unisys on a topic that the SEC has found problematic in other instances. So there's a case called Blackboud where a similar issue came up, and I think in the R.R. Donnelly case that was earlier this year, which involved a $3 million penalty, this thing came up again. And it is an issue where the policies and procedures within the company for cyber fail to articulate in a meaningful way how the frontline cyber folks know when to escalate and who to escalate to. And if you don't have that information flowing to the people making materiality determinations and the people making decisions about what to disclose to investors, those other functions aren't going to work properly. Like, those functions depend on a free flow of information of appropriate details. And the only way people know what to share is if there's some process in place that gives them guidance. So if you fail there, the SEC is going to find a problem with it likely, and have a number that is probably not going to be super helpful for anybody as far as what the penalty is going to be. They've said it a number of times, and now I think they're getting serious about it, at least in this administration. One thing that's worth mentioning we haven't yet discussed is this is sort of a great retrospective view of how the SEC looks at cyber, but I think we are on the cusp of a new day at the SEC. There's a new chair that has been nominated, has not yet been confirmed, and the 2 Republican-appointed commissioners, Commissioners Peirce and Ueda, filed a dissent against these 4 recent October SolarWinds customers' orders, in which they felt like the SEC took the wrong approach here. They said that some of the concerns that the SEC expressed about what was disclosed were things that, in their view, the guidance had said companies don't need to disclose. And it was more focused on details of the incident rather than impacts. And the guidance had been, talk about impacts. Don't worry so much about the details of the event. And so, in their view, the commissioners felt like this is more of a footfall issue, and that not the sort of thing where the SEC should be focusing its enforcement time and priorities on. And so, in a new administration, we may be looking at different issues, but we can talk, I think, credibly now about what the view has been to date. And I think always, if it looks like the company is just dramatically underinvested, knew about risks and didn't deal with them, told people they were safe when they knew they were vulnerable, those types of things will remain, I think, problematic regardless of what the administration looks like.
So, Saša, I mean, that's a really interesting point, and I think one big question around all of this is, of course, if the SEC's oversight is limited to companies that are publicly traded firms, as well as organizations or individuals who do work in securities industry. But the economy is much bigger, and the trend is for companies that are public to go private rather than private companies to go public. So, Saša, I'd be interested in your thoughts. We applaud the effort to get more transparency out of firms about cyber incidents that are happening that might affect them or their customers, investors, and so on. What do you think the point of the spear should be for the federal government as they look to get more transparency around cyber incidents?
Yeah, I mean, I think you bring up a very important point that don't hold me to the exact number, but I think it's close enough. Where something like in 2002, I think the size of the private markets or private equity held markets was something around 980 billion. So something just shy of $1 trillion. In 2023, I believe that number jumped to like 26 trillion. 26 trillion. So in 22 years, that economy did a 27, 28x, something like that. Those are not, numbers that are mirrored on the public markets. So, so we have to kind of, to some extent, analyze the incentives for why did that side of the economy grow so much? And I don't think it's arguable, and I don't think it's controversial to say that, public markets have over the last 20 years, in gross, not with any given administration that ebbs and flows left and right, but overall, we've seen a rise in, everything from the beginnings of, now you have Sarbanes-Oxley and you have to report financially differently to, extra SEC scrutiny to extra, well, you got to file this and, oh, you have to advertise your, I don't know, carbon credits and all the things that kind of add friction and add cost to doing business. Some of them can be fantastic efforts and very worthwhile, but they're still, no one would argue that they don't cost money. They are additive to a business. They slow things down, they're additive to a business, and they make it more complex to operate. So where, the old adage for startup companies used to be, boy, one day when we IPO, now that's not necessarily the most desired outcome by most startups, right? Is they're like, well, look, if we have no other options, we can always IPO, and it sounds bizarre for people to hear that, but, think about what is the reason why you IPO is to have access to a whole new level of capital. And if the private markets have all of this capital now, meaning you don't have a reason to go into public markets for capital, then sort of why would you? Why would you go do that? And so
You do
the
get to
reason
ring the bell on the New York Stock Exchange. That's the other thing.
you do get that. You do get that. So
just saying.
Yeah, absolutely. The reason I'm highlighting this is so people understand the context about behind what I'm about to say, which is what we're seeing is that more and more companies are staying or never going public, right? Or excuse me, they're staying private or never going public, or if they're public, they're going private. What that's doing is it's putting more and more of the economy, but maybe more importantly, more of the vendor solutions we rely on. Go see the last time you've heard, so and so company that your enterprise might use has now been bought by, insert your favorite, whatever private equity or whatever here. That is probably being done for very good intent to make them leaner, operate more efficiently, to maybe reemerge back in the market one day, maybe not. But the point is, the minute they do that, they are no longer under David's former colleagues, and former organizations sort of scrutiny. So it's not like they don't have investors. They have investors. They have limited partners who invest in them, right? Those LPs are often, state firefighters funds, they're teachers unions, there's lots of people who are investors here who also need to know that the solutions that they're buying from these companies, or that they're investing in, or maybe through their pension or something like that, does not carry adverse risk. It's not appropriately represented or disclosed. And that is not under the kind of the umbrella of the SEC. So I think what's important to remember, especially if you're out there and you're, for example, consumers of software, let's say you're buying software from solution providers out there, just know that, what you should hold them to the same or higher standard for providing you security assurances like you would a publicly traded company.
So we have a question from Uluwole, who has asked, to what extent does cyber insurance mitigate the risks of an SEC penalty or regulatory penalty? Really good question. A lot of companies obviously invest heavily in cyber insurance. Any coverage for this type of thing, David?
So I've heard of cyber insurance that will protect practitioners in the context of a cyber incident. And it's not necessarily cyber insurance, it's more like E&O insurance, but for cyber professionals. And I think that will pay for an attorney, will potentially pay for a settlement amount. Typically there is a intentional fraud exclusion, but the SEC has traditionally brought in these contexts almost always like a lower level of fraud based on negligence. Is you got it wrong because you weren't paying close enough attention, which is different than you were intentionally trying to deceive your investors. And if you're in the negligently blundered into the wrong disclosure, I think there's likely still covered, but obviously each policy is different. You need to check it. As far as like reducing the risks of an actual penalty being imposed by the SEC or regulatory action being taken, I don't think it has any impact. It's more about who's going to bear that risk if it comes live. And hopefully if there's adequate insurance, it's the insurance company, not the individual.
Okay, so we're coming up on the end here. So if you do have a question, then one just dropped into the Q&A, added to the Q&A. We'll try and get to it before we quit. Last question I have, David, obviously the case against SolarWinds was eye-raising back in 2023. The case against its customers in October also got a lot of attention. However, as you pointed out earlier, there have not been subsequent cases like this where the SEC delved into a company that got breached, Change Healthcare or whatever, and said, "Oh, hey, look, this you filed this 8K or this 10K, but you knew about this breach." So we haven't seen the same level of scrutiny on other companies, even though there have been a ton of incidents. Why? What's going on? And is this a test balloon from the SEC and they're going to just see it through the courts and then do more, or what? How do we understand? How do we comprehend that?
So stepping away from anything I might have observed while at the agency through June of this year. So taking it to a couple level. Well, I do, because I've got
yeah.
Obligations as a former officer and as somebody who's got confidential information. But so taking it to a couple level of abstractions, not talking about any individual company, the SEC, I think for good reasons, has a policy where they will not identify the fact that they have an investigation that's ongoing, because you never want the mere fact of an investigation to harm a company or its shareholders when there may have been no violation at all, nothing bad may have happened. Most investigations, I think, eventually get closed without enforcement action. And so keep that private until there's something that needs to be shared publicly, because you're going to go forward with a resolution or litigation. So I think it's just important to know that although we haven't seen the enforcement actions that you referenced following some incidents that have been publicly disclosed, I don't know that there is an ability without some public statement from the SEC to know whether or not they've made a determination, or whether they're looking at it, or whether that just hasn't risen to the priority list yet. There's some long statutes of limitations and lots of companies and limited resources. And so sometimes things just take some time. But also, I think we're going to be seeing a change in approach, whether it's because a test balloon or because new administration. But I think we're likely to see some changes. And so hopefully we get some guidance so we understand what those changes mean or why they're coming.
So don't infer too much, I guess, is what you're saying.
That would be that's always my advice. The fact that we haven't seen something doesn't mean something isn't happening.
Yeah. Okay. So we have a couple questions that dropped in. If I could get to them before we break, it'd be great. Michael asked, with cyber insurance getting harder and harder to get, what do you think, will there be an impact in the roles? I'm guessing like the CISO role. In other words, I'm guessing would insurance companies start to compel companies to make some of the changes that we've been talking about in terms of accountability or investing in cyber? Saša, I'd be interested in your thoughts on this.
I think cyber insurance is, one important tool of many in your toolbox. So think about the 4 things we can do at risk, right? We can mitigate, we can eliminate, we can, we can eliminate entirely, we can accept if the appropriate person with the appropriate authority accepts it. And the last one is we can transfer, and we transfer by buying insurance. Yes, you might be a little bit more limited in your ability to transfer by doing that. But, I think of cyber insurance as a little bit analogous to like trying to get, flood insurance in Texas or Florida, where all the insurers have pulled out and said, we're not going to underwrite that anymore. And the state has come in and backstopped and said, yeah, but that's still necessary. So I can't see the market being without these solutions. They just might be delivered in a different format in the future if the direct insurers end up being kind of priced out of the market, or they just find that they've been paying out too much. But one positive about this is this industry went from, I would say, an industry that knew almost nothing about the space to an industry that is now maybe the smartest in the space, because they had a couple of years of payouts that were too high, and they went and they added horsepower, they added quants, and they added, data science and analytics people, and they started generating, actuary tables needed to start projecting this stuff. And all of a sudden, the cyber insurance industry is actually a really well-informed industry on cyber in the last couple of years.
Okay, so we're at the top of the hour. I thought that before we go, though, just give David and Saša just some closing thoughts or comments for the folks who attended.
Yeah, just wanted to thank everybody for the opportunity to be here. Really enjoyed the discussion, Saša and Paul, and hope everyone stays safe out there, and looking forward to seeing what the new administration, their approach is going to be, and how that hopefully makes us all safer from a cyber perspective.
Thank you, David. Thanks for joining us. Saša.
Yeah, I want to thank you, Paul, for such a masterful job at moderating as always, and David for his thoughts. I would leave folks with just maybe one thought that is not mainstream cyber, which is, don't get distracted by what maybe ends up being the shiny object in the industry in any given quarter. Don't lose sight of the stuff that your enterprise actually runs on. So, don't lose sight of things like, while people are talking about, risk being an open source, your company doesn't run on that. Your company runs on commercial packages. What do you do about that? Don't lose sight of the fact that, the most important job that your CISO can be doing, or any security or risk professional, is simply informing the business about the totality of risk. And then someone in that business needs to make the decision. Some of those fundamentals are so important, and we sometimes lose sight of them. Beside that, I would just tell everyone, I hope you have a fantastic holiday season, and look forward to chatting with everyone in 2025.
Absolutely. Thank you, everyone, for attending. Check out, we got some more webinars coming up before the end of the month, so check them out. And thanks. We look forward to seeing you all again. Check your inbox for the link and the follow-up email, and let us know what you thought of the presentation. Saša, David, thanks so much for joining us.
Thank you.
Thanks all.